do have an ongoing concern, as you know, about disposing of Cedar Haven. I have some information that I would respectfully ask that you review for my colleagues and the county as a whole. Perhaps you already did review this and have answers. But I think that history is important to know and review before moving forward to make sure that our future is secure. In 1830, on March 16th, this deed was instituted, and it was passed as an act entitling the erection of a house for the employment and support of the poor of the county of Lebanon. From David and Barbara Fisher, they had a plantation, and the amount was $11,691.13 for 160 acres. To quote, it says, whereas the legislature of the state of Pennsylvania did wherein, among other things, it is enacted that the commissioners of the county of Lebanon shall have the power to direct that a house for the employment and support of the poor be erected in said county. And Adam Ulrich, Philip Spittler, John Stauffer, Philip Lease, Jacob Arndt, Jacob Weiss, Michael Core, Leonard Kapp, and John Harper were therein appointed, whose duty it shall be to determine upon and purchase a site on which the said building should be erected, and or the said persons, or a majority of them, to take a conveyance therefore in the name of and for the use of the corporation mentioned, together also with all and singular the houses, outhouses, barns, stables, gardens, orchards, meadows, fields, fences, ways, woods, waters, watercourses, rights, liberties, privileges, hereditament, and appurtenances whatsoever thereunto. The directors of the poor and the house of employment for the county of Lebanon, their successors in office, and assigns to the only proper use, and behold of them, the said directors of the poor and of the house of the employment for the county of Lebanon, their successors in office, and assigns forever under and subject to the payment of the sum of £79, 15 shillings and 2 pence yearly, and every year unto Magdalena Sipes, who was the widow of Jacob Sipes, deceased, during her life, being the yearly interest accruing on the principal sum of £1,329, 6 shillings and 4 pence. Which remains charged on the premises for the use of the said Magdalena Sipes during her life, and also subject to the payment of said principal unto the children of the said Jacob Sipes deceased or their legal representatives, according to the order and the decree of the Orphans' Court of Dauphin County made on the 19th day of January, A.D. 1806, in relation to the said premises, then a part of Dauphin County, and according to the Act of Assembly in such case made and provided. Then we move on to the Act of June 24th.
Excuse me, what is the purpose? Wouldn't it be better for our council to have a chance to review this?
I would like it read publicly. I'm almost done. I'm halfway through. Then on Act of June 24th, 1937, 2017-396, to the Lebanon County Institutional District per County Institutional District Law, Article 3, Section 301 and 302, which abolishes the county poor districts and transfers the property, obligations, powers, and duties to the county institutional district. Quote, the commissioners shall be the executive and administrative officers of the institution district of that county, and the county treasurer shall be its treasurer. The commissioners shall employ each of the present paid county poor directors until his existing term of office shall expire. Now we move forward to the Act of August 9th, 1955, PL 323, number 130. To the County of Lebanon by the County Code, Article 21, Section 2161. And as far as I know, this is the current code that we must follow, which abolishes the county institutional district and the district and transfers the property to the county. I quote, all indebtedness, whether current or bonded, incurred in the acquisition of any such property and in erecting improvements thereon, shall become the debt and obligation of the institution districts in connection with administering their affairs, are hereby transferred to the counties in which such institution districts are located. Section 2163, Powers and Duties. Their duty shall be 1, to erect, equip, maintain, repair, alter, and to add to institutions for the care of dependents, and to equip, maintain, etc. Any plan for the erection or substantial alteration of an institution must be approved as to suitability by the Department of Public Welfare. And number 2, to pay the necessary expenses of land and buildings for the care of the dependents. Section 2164 goes on to say, commissioners shall have the power, and it shall be their duty with funds of the county, according to the Department of Public Welfare, to care for any dependent having a settlement in the county who is not otherwise cared for, and it goes on from there. And I'd really appreciate if you would look into this and report back to us before settlement so that we know we're making an informed decision, because according to this, we must continue to take care of the poor if they have no place to go. And if we sell Cedar Haven, we will have no place to house them. There's a lot at stake here, I know. But to bring this to your attention after settlement would not be appropriate. It needs to be done now, in my opinion.
Context of the real estate, the property certainly is and was deeded to the directors of the poor and of the House of Employment for the County of Lebanon. And through various statutes, I think some of which you referenced there, effectively the state legislature eliminated that function or that board or whatever official capacity they had given that, and the county commissioners replaced that. We've actually done some research on that and gone through that with the buyers and their title company, and the deed will be written and is written as the County of Lebanon, successor to the Directors of Poor and of the House of Employment for the County of Lebanon. In the general context, when transferring a deed, we're transferring all the legal ownership to a property that we have and that we believe we have. And that's what we're doing by this deed. We're transferring it. It's the buyer's obligation to some degree and their title insurance obligation to ensure that there are no liens, encumbrances, anything else affecting their clean title to the property. And that's frankly why people buy title insurance, to kind of ensure that they're getting a good, clean, marketable title without any of those encumbrances and other things that could be an obstruction on their title, that other people could have a claim or a right or an interest in that property. So we transfer, as a seller, we transfer all of the rights, title, and interest, everything that we have and can legally transfer. That's what we're transferring. The buyer has to be assured, satisfied through their own investigation, inspection, things like that, that they're getting everything they're expecting to get from us. And again, every indication I have, they've reviewed all these documents, they've approved all these documents. Every indication I have is that they are completely satisfied that that's the case, that we, the County of Lebanon, by and through the county commissioners, have legal authority to transfer the title, that they are satisfied that we're transferring a good, clean, marketable title in the form that we presented to them, and that they are having a licensed, bonded, insured title insurance company who is issuing them title insurance for this transaction to ensure that they are getting a good and clean title. As to our obligation as a county to continue to maintain and provide for the poor and indigent, things like that, there is a specific section of the county code now that authorizes not just the sale of real estate, but actually the sale of real estate, including an institutional home. That I don't know the section citation off the top of my head or when that was passed, but that was passed fairly recently, I think, in consideration of giving clarity to how a real estate transaction relative to the sale of a county home was to occur.
My mother always used to tell me that if your friends jump off a cliff, will you also jump off a cliff? So due diligence is in order, and I think it's more than a handful that still own their county homes. And I think all this took place because we were told that the counties don't have an obligation to take care of the poor. And that premise was flawed. We do. It's still on the books.
Heirs to the property. That property you read was the property. It was known as the Almshouse, poorhouse. That was, I believe, an entirely different property across Metro Drive, in the area of Med-Ed, and that whole fields. It was.
I know the acreage is much larger.
Repeating a little of what you said, but as far as the directors of the poor and the institutional district and so on, that was researched extensively because the buyer had asked about it, and I think you're in your complete rights to be able to transfer this property, because directors of the poor in the 1930s were transferred over to an institutional district. Institutional districts were dissolved, transferred into the control of county commissioners across the Commonwealth. The part of the county code that addresses care for the indigent, it says if not otherwise cared for, if I'm getting the right terminology there, the right wording, if not otherwise cared for, it's the responsibility of the county. But since the mid-1960s, when medical assistance and Medicare were imposed, Medicaid, there really isn't anyone any longer who isn't cared for. They're being cared for by their entitlement to medical assistance, or Medicare and Medicaid, that's paying for their care, whether they choose to go to Cedar Haven or another nursing home anywhere. The care that payment follows them. You know, I don't believe there are very many, if anyone, left who truly is not cared for otherwise. And that's the otherwise as you read, 1955 was when the county code was written and instituted. That precedes the implementation of Medicare and Medicaid in the 1960s.
But to restate something that I brought up early on is that our population is growing. No additional Medicaid beds have been approved by the state because they don't have money to pay for them. And with more and more elderly in a baby boom generation hitting that age, there's going to be competitions for beds.
What does that have to do with this transaction? Those beds are still going to exist in the same percentages that they exist now. So how does that have any relevance to the problem of long-term care for the growing population?
Because it is our asset, and we had a closed wing, we could have reopened, we would be able to take care of it without an additional outlay of cash to purchase additional property. In other words, I see us with this responsibility and setting up the future with no place to put people.
But you just said they're not approving any more beds, so how would you?
But we would still be responsible to take care of them. And if we had the space and we had the real estate, we would be able to do that.
Okay, I'd like to bring this to a conclusion by saying I'm not interested in spending any more money on an attorney to investigate this any further. And I am a little offended that you brought this up the day before, or 2 days before you thought settlement was going to be to hold up settlement. I think that's very inappropriate.
And it was not held, it was only on my part researched, it was not shared with me. So it was only on my part researched in the last 24 hours that I was able to get to this point.
With all due respect, Chairman Litz, did you request, this process has been going on for months and months and months and months. Did you ever make a request of our solicitor to assist you in this deep research that you've done?
You know,
Did you?
No, wait a second, sir. You asked me a question. I'm going to answer it.
I'm saying that there probably would have been help
You
had
asked
you
a
requested
question, I
it.
would like to answer it. I should not have to beg for information. It should be presented so I can review it before a vote, period.
Solicitor Warner, do you need a motion today? I had asked that question earlier.
No, I'm satisfied that all the documents, again, through our various motions approving the purchase, approving the asset purchase agreements, that these would just be in basically in following through with those and signing all the documents necessary to get us to settlement, so we can take care of this after the meeting to sign and have everything notarized.